Welcome to Empowering Plans, a show dedicated to identifying waste and undue expense in the health benefits industry, discovering ways to maximize benefits while minimizing costs, and empowering employers, administrators, and consultants to emphasize, once again, the benefit in benefit plan. Today's episode is brought to you by the FIA Group, empowering plans since 1999. Now here are your hosts, the FIA Group's own CEO, Adam Russo, and Senior Vice President and General Counsel, Ron Peck.
And Brady.
Hello, everybody, and welcome to another podcast of Empowering Plans with the FIA Group. It's a great day here at FIA. The sun is out. We're happy. As always, the infamous Ron Peck. Say hello, Ron.
Hello, Ron.
And as everyone knows, we had no choice. We now have to have Brady on the intro music based on all the response that we got. So guess what? Say hello, Brady.
Hello, Brady.
Brady is here. Brady will always be here. He is now a permanent fixture on our podcast, Ron.
He's been evicted from his home. He lives here now.
Just so everyone knows, if you could picture the FIA podcast room, Ron is in the corner sitting on a milk crate. Brady has taken the big, cushy leather chair. Sorry, Ron, but it's either you or me that are off the main stage, and we know I'm not going to get off.
Adam, milk crates breathe a lot better than leather seats.
That's awesome.
Airflow.
So if you heard that female voice laughing just a second ago,
That was Brady.
Come on now.
I know people want the visual. We apologize. We can't. You just get the lovely voice. We brought her back based on popular demand. Say hello, Jennifer McCormick.
Hello.
Did you notice how she doesn't say Jen? It bothers the heck out of me. She doesn't do it.
Not me. She respects my creativity.
So, okay. So something new, a little twist. We had an amazing webinar yesterday. The highest number of followers, the highest number of viewers, by far the most questions and comments that we've ever received in an hour-packed webinar before. Based on that, we felt it was important to focus on the one topic that seemed to get the biggest response. It got people's juices flowing, and that's surrogacy, and whether a surrogate pregnancy and the delivery of a baby should be covered by a self-funded plan or not. So that's what we're going to focus on today, and that's why we brought Jen to assist us, because she's been really involved in this topic. As you said yesterday on the webinar, Ron, and feel free to add to it, there's a lot of mixed emotions here, both from a, just a passion of, women's rights or who can tell me what I'm allowed to do, to this discriminatory versus why as a self-funded employer should I be paying for someone who's profiting from this? Is it a workers' comp exclusion? Is it a subrogation? All these different things. I figured today is a good way to topic moving along. Let's get deep into it. What do you think?
Yeah, definitely. This is actually a really good topic to discuss for a number of reasons. One, surrogacy in and of itself is actually not a single procedure or a single condition or a single service, but a chain of events, right? So the first service being the actual surrogacy itself, where they're implanting the embryo, they're creating the pregnancy, that surrogate procedure. Then there's the actual pregnancy itself and all of the ongoing care. And then, of course, there's the delivery. And Adam, like you mentioned during the webinar, that delivery is a crapshoot, right? It could be healthy, no problem, or you could have all sorts of complications.
And that's the first thing, right? So when we ask people if this is an issue, a lot of people, you hear nothing. I don't think most people would know. Most deliveries are normal. Most deliveries are, all right, the baby's born. It's not an ICU. It's not a preemie. It's not $1 million spec claim. How in the world would you even know that it's a surrogacy-related delivery or pregnancy?
Great point. Surrogacy, like I said, is generally broken into these three stages: the surrogacy itself, the pregnancy, and the delivery. And most plans would hopefully exclude the surrogate procedure, the initial procedure.
But that's the one that would actually help you know that this is happening.
Bingo. And as a result, not only that, but the vendors, the people who are involved, they know that insurance, whether they exclude it or not, will probably push back. So they're willing to kind of sweep that under the rug, figure out a different way to cover that cost.
So Jen, tell us what the issue is. Tell us what's happening across the country. What's the next step? What's the opportunities? What's going on?
Right. So when it comes to surrogacies, I think the first issue that you're going to run into here is that how do you even know whether or not the individual is acting in the capacity of being a surrogate? And it's not uncommon across the country, especially based on how self-funded plans are set up, for a plan to be covering fertility, infertility type benefits.
If I put a gun to your head, what percentage of the time does a plan cover those type of benefits?
I would say at least 60% of the plans cover to a certain extent, whether it's a once per lifetime, $50,000 lifetime with maybe some sort of limit. The majority of plans do cover some type of fertility treatments. So based on covering some type of fertility treatment, when I say I go in there, say I'm carrying somebody else's child, Does anyone know whether or not that's mine or somebody else's? That's not part of the conversation. That's not part of the conversation that I'm willing to share. So even though that is potentially going to be a covered benefit under the plan, and it does start there, that's not necessarily a conversation that the actual employee is going to be having with their employer. And also remember the separation here from HIPAA. There's a separation between what the plan is required to know and what my employer is allowed to know, because there's a plan sponsor versus the employer relationship. So you're not allowed to cross that line. So not only is this a potential issue about whether or not I'm being a surrogate, but even if the plan has knowledge about that, are they allowed to share the information, or the employer has information, can they share that information with the plan sponsor?
So the first decision that a plan has to make is, what do they want to cover? Am I right?
Right.
So what are the things that need to be covered, and what typically happens?
So first is the contraceptive piece. So actually getting impregnated with the actual fertilized egg.
So you could deny that. We could exclude that from coverage.
Easy. No problem to deny that. No
Nothing
one is
to discuss.
arguing.
And we've seen those exclusions, the surrogate procedure exclusions in the plan
But
document.
that's typically cheap, I'm assuming.
Yeah, it depends on the number of temps or the extent of the procedure, but yeah, not necessarily a high-cost procedure to have that covered. Step 2 is as you are pregnant, there are maternity type of prenatal exams, visits. You go to the doctors monthly. So that is typically a covered benefit under the ACA preventive care rules. So we know that whether or not this person is being a surrogate, under the ACA preventive care rules, you are required to cover those services.
Very important, Adam. One of the things that you just hit on is one of the arguments that people have brought up, right or wrong, that because the actual surrogate procedure was excluded, do these then subsequent pregnancy care treatment, ultrasounds, etc., because they're a result of an excluded claim, are then excluded, same as, an infection that would normally be covered. If it's the result of an excluded cosmetic surgery, the plan now excludes that. That is something that's been brought up and that we've had to deal with.
So in discussing this, we refer to it as the earlier foundation exclusion. The problem with that, though, that I see, if you look at the laws that apply in the case of surrogacy, we just talked about the ACA as one of them, but the Pregnancy Discrimination Act is really the biggest law that applies in this case. And essentially, it basically says, it amended the Title VII of the Civil Rights Act, saying that you can't treat a woman differently if she's pregnant, essentially. You can't base treatment decisions on her condition, being pregnant, or other related conditions from pregnancy. So with regard to, if you're ill and then you have a complication arising from that, and how that relates to surrogacy claims, the difference here is that pregnancy claims are special. You can't treat them like every other claim in that context if, as a result, you're discriminating against women. So you got to be careful how you structure that in your plan.
And the only controversial thing I'm going to add to that is that there still is a interpretation that you can exclude any maternity-related charges for a dependent child.
We've talked about sort of the related to an excluded service and why this is different than a surgery infection from a excluded surgical. The next arguments that we've heard is, well, can I exclude this based on working for wage and profit, or subrogation, third-party liability? That's the next argument that came up.
I think the issue there is that what the case law tells us is that you can't really rely on an exclusion which is sex-specific, meaning if it's just targeting women, if it's narrowly focused, that's not okay based on the case law that we've looked at. But when you talk about these other more generic exclusions which apply to all genders or third-party liability, so the issue there with workers' comp is surrogacy really work? So most
if you look at the plan language,
right,
getting a wage or profit, right?
Yeah, you can get around that with broader plan language that just says
that the FIA group offers,
profit.
by the way.
Sure, yeah, but because the deal is that most surrogacy contracts don't provide compensation; they're covering your expenses. So they're careful with how they word the contract. So it could be difficult to classify that as work.
Right, you are being reimbursed for the inconvenience. You're not being paid to carry somebody else's baby. It is illegal to buy a baby. You can pay for maternity clothes. You can pay for rent. I'm not getting paid. I am just being reimbursed for the inconveniences.
Ask anyone who's pregnant. They'll tell you this is work.
Right.
There's a reason they call it labor.
Right.
So,
that's a good point, Ron. It is labor. Bam.
But if I am pregnant, that doesn't mean that I can't have a job. This is not my job to carry somebody else's baby.
Don't some is it possible that some women use this as a job?
Maybe they do, and maybe it depends on how you're being treated and how your employer is treating you. Are you going to consider someone being pregnant to have a second part-time job?
So here's what I got. So far on the workers' comp subrogation argument, you're seeing two different points of view, right? It's clear that it's not as black and white as some of the comments suggest. Oh, yeah, deny it as a workers' comp exclusion. That might not work. Is that what you're telling us, Brady?
Yeah, it is. And I think the third-party liability exclusion is actually a better way to go. It's stronger because in this case, you're establishing third-party liability under the surrogacy contract. That's what's telling you the intended parents here are the third party who are receiving the benefit of a baby, and they're the ones that are usually in the contract paying for the expenses. So here you have a simple subrogation case. You have a third party who's basically admitting liability for claims, and if the plan can get a copy of that agreement, which is not that easy to do all the time, but if they can, then just exercise the subrogation rights.
So really quick, there are some states where this isn't an issue, correct?
Right, there are some states where it's illegal to be a surrogate. So if it's illegal to be a surrogate, it's probably okay to exclude it on your plan, right?
Right. In addition, there are some states that say you're required to cover the delivery of a surrogate's child, a baby.
Like Wisconsin, yeah. Wisconsin has a special statute which says you have to cover surrogate claims. That's separate from any federal law.
So another thing to note as far as the states are concerned, interesting enough also, there are a lot of nations in Europe where this is also illegal as well. And so as we talk about people being compensated, structuring the contract in a very clever way, knowing how to get around the laws and knowing what's legal and what's not, you probably think, well, you know, somebody who's willing to be a surrogate, they're probably not that sophisticated. They don't know all this stuff. What's the issue? The issue is that there are actually professional organizations who have literally built their business on the fact that they can take people in these places, states, nations, where it's illegal to have surrogacy, and they're hooking them up with people where it is legal to be the surrogate. So as you start to think to yourself, oh, hey, why are these people so sophisticated? How are they coming up with all these sneaky tricks? It's because there are literally teams of attorneys and business people who have built their entire infrastructure around that. And to that point, the fact that there are attorneys on staff are businesses that have built themselves up on this entire concept of taking people where it's illegal and pairing them with people where it is legal. We're now starting to see litigation because, again, these are gray zones. If it was black and white and we knew the answers, we wouldn't be having a podcast about it. And as a result of these lawsuits, a lot of these questions are now starting to be hashed out in court. And I don't know if you guys want to talk a little bit about some of those cases.
I have one I want to jump in with real quick, which is actually an ongoing case and worth looking up. It's called Gonzalez versus Marriott International. It's a case in federal court in California. Essentially what happened there is you have a woman from Los Angeles County who sued the Marriott hotel chain because they did not allow her time for breast pumping. She's a surrogate mother, and Marriott's argument is, look, pregnancy accommodations are required only for mothers and not surrogate mothers. So they're making a distinction there. Of course, the woman sees otherwise, and she has sued. And so far what's happened is the judge has rejected a motion to dismiss filed by Marriott, saying that, no, actually, a reasonable jury could conclude that surrogate mothers are protected under the Pregnancy Discrimination Act. So it doesn't exactly address the issue of surrogacy claims, but it does address the issue of whether surrogate mothers are a protected class in the way that regular mothers are. So we'll wait and see how that one plays out. Could be a big deal, though, going forward.
Yeah, the other thing that I want to add when we're talking about this, Ron, you mentioned this, is that there's a big business in surrogacy. People find this something that they need, something that they want, maybe if they can't carry their own child, and maybe they can afford it. And one of the things that we deal with is cost containment, right? Opportunities where we can save money. Knowing that this is a business, people have been starting to offer surrogacy insurance. So there are situations where somebody can buy insurance for themselves to carry their surrogate while they're acting as a surrogate, those maternity type claims. So maybe this is similar to something like an organ transplant rider, where a self-funded plan look into the opportunity knowing that the case law is unsettled. We don't know how this is going to go. We know that there's a couple of things that are clear. You can exclude fertility treatments under the plan. You have to cover ACA preventive care. But when it comes to that middle ground, that labor and delivery, we don't know what the rules are. But we do know, as you mentioned, that's a crapshoot. We have no idea if this is going to be a high-risk situation or a regular delivery or maybe a very expensive one. So maybe having a surrogacy arrangement insurance agreement for that particular individual is one of the ways that we can look to contain costs. We know that they exist.
So it's interesting, stepping back for a second, a lot of the arguments that have been brought up using your traditional plan and your exclusions, We've already talked about them so far, but just to review, the actual procedure itself, the implantation of the embryo, the surrogate procedure, you could, as far as we can tell, exclude that, but these businesses know that and they figured out how to deal with that. Next being the actual pregnancy and all that treatment. The fact that, there's this argument, well, if it's the result of an excluded procedure, can we deny that as well? Like I said before, same as an infection as a result of a cosmetic surgery, but unlike a surgical infection from cosmetic surgery, which has no extra legal protection, these types of procedures do under numerous laws. You've mentioned now the ACA as well as the Pregnancy Discrimination Act. Additionally, on top of that, we then said, okay, well, if you can't exclude it, can you get the money back, i.e. subrogation? And again, we've brought up the fact that, yeah, but you know what? Unlike third-party liability, where someone is liable for the medical expenses, here, you're not necessarily by law required to pay these medical expenses. You're voluntarily agreeing to pay for certain types of expenses, and maybe you can't dip into that money. And then we also talked about the workers' compensation exclusion and the fact that despite the fact that it's called labor, is it really work for profit, or rather, are you just having someone compensate or pay for certain expenses that are auxiliary to something you're doing, otherwise out of the goodness of your heart as a volunteer? So there's a lot of these counters and arguments and counters to the counters, and that's why we're seeing these lawsuits, and that's why it's not as simple as just maybe adding one piece of language to your plan document, though I think you would agree it's extremely important to update your plan document and at least do everything humanly possible today in the state of the law now to get your plan document as airtight as possible, because frankly, if you end up being the one in court, you want to make sure you have the right language in place. So thinking about that, the last example I want to give is people have also compared this to adoption and the argument that if somebody is carrying a baby to birth, they deliver the baby, and then they put the baby up for adoption, certainly we would all agree that the plant can't go back and say, well, if we'd known you were going to give this baby away, we wouldn't have paid for those ultrasounds. We wouldn't have paid for the delivery. You can't say that. But of course, the argument against adoption and surrogacy being essentially the same thing is that with surrogacy, you literally became pregnant with the intent of carrying this baby and giving it to somebody else. Whereas with adoption, it's more a decision that's made during the pregnancy or following the pregnancy. But I imagine it would be hard to discover somebody who literally went through the trouble of becoming pregnant specifically to give the child up for adoption. So there are a lot of differences, I think, between a surrogate and someone who ultimately ends up giving their child up for adoption. And that third-party interest, I think, is the big difference there. One, they're the driving factor behind the pregnancy versus the other, they just happen to be a beneficiary on the tail end. And, with that, I guess, thinking of these third parties, one thing I want to remind people is be aware of when the parent takes possession of the child, because up until now, a lot of the claims we're talking about belong to the mother, the plan participant. But if there are claims incurred by the infant when they're born, if the participant, the one who carried the baby, is no longer the legal guardian, right, of the baby because it's been taken, the possession has been taken, call it adoption or whatever else you want to call it, or since it is their biological child, just the parent is taking possession of the baby, that baby's claims may not actually be the plan's responsibility because the participant is not the parent. So that's another thing to keep an eye on is once those claims flip from the participant to the child, hit that red mark right there, flag those claims. So Adam, what do you think?
I think we had a great discussion today, folks. It was amazing. I'm hoping that we keep this opportunity going, this dialogue going in regards to other topics that we have on our webinars. So everyone, thank you on behalf of Ron, Brady, our special guest, Jen McCormick, and myself. Thank you for empowering your plans with the FIA Group. Have a good day.